Same appearance, my lord. My lord, before recess, I referred lordships to the conclusion of the Supreme Court, where the Supreme Court, that is at page 879 of the record, it's at 880 in fact, where the Supreme Court said that, concluded that the provisions in the National Identity Card Act and the Data Protection Act for the storage and retention of fingerprints and other personal biometric data collected for the purpose of the biometric ID card of a citizen are unconstitutional. The question is, if the storage and retention of fingerprints are unconstitutional, why is there the obligation to give fingerprints? Why the state requires appellant to give his fingerprints? And where is those fingerprints going to be stored or recorded? This is the question. Yes. My lord, one justification that has been put forward is that it is in compliance with public order. And we can see the National Identity Card Act, duty to be registered at page 1133, section 4, makes it an obligation for the Mauritian citizen only to give fingerprints. There is no obligation on foreign residents residing in Mauritius, expats, expatriates, for tourists, for foreign workers in Mauritius, working in Mauritius under contract. No requirement, no such obligation. And therefore, it is my humble submission that this issue of public order, the more so that no evidence has been adduced, cannot be a limitation to section 9, subsection 1.
Was this point raised below?
The Supreme Court says that this would be in line, that is, the taking and recording would be in line with public order in their judgment.
Yes, but was the point about foreigners and tourists not being within the ambit of the Act, was that argued below?
We have approached the issue that it is discriminatory for...
Well, that isn't my question with respect. Was it argued below?
Yes.
Was it? Can you point to it being dealt with in your submissions below, or in?
The issue was raised in cross-examination of the representative of the respondents.
But was it actually argued as part of your case in submissions?
No. I must confess that it has not been raised in oral nor written submission. On the issue of fair hearing, my lords, I have already elaborated on same in the statement of case, paragraph 101 onwards, page 40 of my statement of case. I would not propose to probe further into this issue, save that appellant, that is, the presiding judge, was hostile to the appellant and to the appellant's counsel throughout examination in chief and cross-examination of respondents' representative in court. And on this issue, the case of the decision of this board in Le Sage may be of particular relevance. It is my humble submission, my lords, that on appeal, counsel do appreciate that the judge interacts, the court interacts with counsel. But regarding trial, intervention should be kept at minimum because it must allow a plaintiff at the end of the day to establish his or her case on a balance of probabilities. And we have made reference to the case of Jones versus National Coal Board. The point has been prophetically put forward by late Lord Denning on this issue. I propose to move on, my lord. My lord, I will end by concluding.
No, can I just say that, to my mind, it's not satisfactory simply to assert generally that there were a lot of interruptions and to say you're not going to go further than that. This sort of allegation, if it's to be taken as significant, needs to be developed in a good deal more detail and in a different way. And I'm not inviting you to do that because it may be too late to do it. But all you've said is that there was an interruption on no less than 75 occasions. How long was the cross-examination of the appellant, and what were the nature of the interruptions? Are you going to take us to any of them to show that they were of particularly egregious or inappropriate nature? For all we know, it may have been quite appropriate. Maybe you're being very sensible in taking it so briefly, but if you take it that briefly, we're almost bound to leave it at that. If there's anything in this, you need to give us some indication that it's worth looking at in more detail.
Why don't we can see that the examination in chief of the plaintiff was throughout interrupted by...
Well, give us a reference. Where are we looking at? You haven't got them, the interruptions listed. I mean, we know the principles. This occasionally happens that judges overstep the mark, but it needs to be. It's a relatively rare case.
We can see the interruptions at the end of the cross-examination of Mr. Raurama.
Right, give us a page. Well, look, if you're going to, Mr. Harry, if you obviously haven't got,
Reference to say between the pages, and even prior to that, pages 320. examination in chief starts between spans over page 300 up to page 333. And
Well, this seems to be an argument, if one can call it that. 320 to 324 is a debate between you and the court about the nature of the issues or cross-examination. It's not an interruption, except in the sense that it started during the course of cross-examination.
Examination in chief.
Sorry, examination in chief, yeah. Is it? Yes, examination in chief. So, right, so you just want us to look at the...
no.
It's simply the examination in chief of the appellant, isn't it, which you're concerned about, according to your written case?
As well as the cross-examination of the representative of the state.
No, I'm just looking at your case. Paragraph 102 is confined to complaint about the examination in chief of the appellant. Well, I think we can look at the examination in chief of the appellant, and if there's anything you want to add to what you said, you better say it now.
So as not to waste the board's time, my lord, I propose to make a list and to offer same during.
Well, you need to make a list because we can read. We are reading and looking at the passages which you've referred us to, I think.
Yes, ma'am.
Right.
To specific parts where we consider the judge was unfair to interrupt.
No, it is simply the examination in chief, am I right?
As well as the cross-examination of the representative of defendant.
Well, where have you referred?
Rao.
Where have you referred in your written case to the cross-examination? Have I missed it?
Donne-moi le chose. Index. Between pages 5 to 9 up to 558.
What paragraphs are there? I don't have the pagination on the secretary.
Sorry.
Page 529, did you say?
Now, I asked you,
Yes, ma'am.
that's the page in the transcript.
Yes, ma'am.
Right. I asked you whether you had referred to this in your written case.
We have made reference only at page 101 to
Yes, you.
105 of the
Yeah.
statement of case.
Yes, you've referred simply there.
Without saying which pages we are involved, because we can see this
No.
approach all throughout.
You have referred at paragraphs 101 to 105, simply, am I right, to the examination in chief of the appellant. You've also said that during a major part of the examination in chief of the witness, the judge was dozy. Well, that's a different point. You've referred to an evidential point in paragraph 104.
That's one.
That seems to be it. So there's no reference to any complaint about the cross-examination of the state's representative.
Yes, my lord. In fact, this is. But we'll have. I propose to list which parts of the interruption I consider unfair and submit to the board at a later stage. And
Well,
we have only...
I don't think we're going to...
I think we're just going to go with this.
Yeah.
I think we just have to do the best we can.
Well, yes, I mean, he shouldn't be allowed, I mean, here's his notice of appeal, denial of a fair hearing, examination of the chief, no reference to the cross-examination of Mr. Rahman. He simply can't, at this stage,
Yes.
throw
Yes.
entirely new points in my humble
Yes, my Lord has pointed to your notice of appeal too, which is simply confined to examination in chief of the appellant. Yeah, so I don't think we're minded to expand the scope of this appeal. As regards the examination in chief of the appellant, you've drawn our attention to the relevant pages, and we can look at them, and that I think is all that need happen. Right, so you're going to go on to another point.
Yes. My Lord, reference has been made by the respondents to the case of Union Campmont versus Government of Mauritius,
What point is this on?
and this is tab 65,
No, but what is
volume
the-
4.
What is the point to which it relates?
That is, we should not import wholesale articles, that is, provisions of foreign constitution whilst interpreting provisions of the Constitution of Mauritius.
Well, nobody is importing wholesale provisions of foreign constitutions,
Yes.
except that I understood you to invite us to import wholesale provisions of the European Convention on Human Rights, which we've discussed this morning.
Yes.
But nobody is suggesting that we read
I would say-
provisions of the American or Canadian Constitution. They are at most inspiration.
Yes, for reference.
Yes.
And,
So
I
do
would
we...
say that the case of Union of Campmont concerned the right to equality, and it concerned a case where the appellants or applicants wanted to challenge the imposition of rate on beachfront properties. And the court said that there is no general right of equality in Mauritius, and we cannot import wholesale provisions of the US Constitution or the Indian Constitution, so that the case of Union Campmont is not relevant to the present case. Reference also has been made to the case of Matadine versus Pointu, where the issue was the short notice of the minister to allow for an Oriental language to be computed at the examination, that is, which was going to take place some 9 months later. So the short delay was being challenged as in breach of the right to equality. And the court said there is no general right to equality in Mauritius. And the board said that it should have been done by way of judicial review, in view that the decision was very unreasonable, and that this decision should be an isolated instance where the board did not review the constitutionality of the act, that is, of the minister's decision, on account that this should be left to the legislature. And it is my humble view that this case also does not find its application here. There has been reference to the case of Sain.
I don't think you have to go through every case which has been referred to against you, unless
Yes.
well, which case is the one that you're just referring to? Versailles. Which is the case you've just referred to?
Matadine versus
Yes.
Pointu,
Yes.
tab 43 in volume 3,
And
pages.
and the union one was which reference?
A4,
Volume
Pages.
65.
Yes. And the third one was the Versailles, was it?
Sain, I
Aye.
understand it would be pas signé. 59, tab 59.
Sign Turkey.
Ah, yes.
It is my humble submission that this is not relevant. It concerned the wearing of scarf at the university against the dress code of the university. This is not relevant. The case of Lila also is not relevant. That is the right to establish schools, a sect known as the Rajneesh Ashram, and this also is not relevant to the present case. Concern the right to freedom of religion.
Which case was this and what was the reference again?
Both cases. The case of Sain versus Turkey.
Yes, I've got
and
Sain.
The case of Lila. I am sorry for the pronunciation. For Der Kreis versus Germany at tab 36.
Right. Right, where you say they're all irrelevant.
They are not relevant to the present case.
Yeah. Good.
It is my humble submission, my lord, and I wish to conclude on these words. If I may be allowed to use the words of the present Prime Minister of the UK, what she said in Parliament whilst she, as Home Secretary, scrapped the legislation, National Identity Card Act 2006, by replacing same Identity Document Act 2010. And it is equally relevant for Mauritius that the National Identity Card Scheme represents the worst of government. It is intrusive and bullying, ineffective and expensive. It is an assault on individual liberty, which does not promise a greater good. And it goes on, it sends a message that the government are going to do business in a different way. That is the government of the UK. And it also goes on to say that we are the servants of the people, not their masters, and every action that we take must be considered in that context. My lords.
Now, you've had an identity card scheme in Mauritius for a number of years, haven't you?
We have it since 2013.
Well, haven't you had one which is not electronic for some years?
We used to have a plastic laminated card.
Yes. Since 1985, is it?
Yes, up to 2013.
Yes. So the objection is not to the identity card scheme, it's to the electronic aspect and all the risks which are attached to that. Am I right?
Of the contactless smart card with RFID.
But
And
I don't know what the British government one, presumably the British government proposal was for some sort of electronic identity card, was it?
what we know in the UK, there is no obligation on the British nationals to give their fingerprints.
Well, we know that, but
Yes.
I was saying that do you know whether the proposal for a British identity card scheme was for an electronic one?
It was a biometric identity
Yeah.
card.
Yeah.
The only feature that is in addition to the Mauritian ID card is a contactless, whereas contact card is like Oyster, one has to put, or like the bank credit card, one has to operate with the code.
Yeah. So the Mauritian one is contactless, so you
Contactless.
don't have to use a code.
Yes, that is the modern generation robber or thief will come with a laptop and will read all the data.
Well,
That's perhaps for next time's case.
we hope not, since most of us carry contactless cards on us to use things like the tube.
My lord, I wish also to note that, to point out that the legislature has tried to cure the mischief, and they came forward with a regulation in September 2015. That is a consent form. That is, though there is the obligation under the law, they come with a regulation to make a person sign that he's consenting to give his fingerprints. In my humble submission, this is that is a colorable device to circumvent what they have enacted.
What is the position relating to the scheme? It's not operating at all, or it is operating?
It is operating.
So everybody else, when was it brought into effect?
It is since 2013. It
I
is
see.
in effect.
But I thought there was some, wasn't your client, or wasn't there some suspension of the obligation to give fingerprints?
It has been extended, that is the delay to register and to obtain this card has been extended to January next year.
Yes.
And that's why we have applied for an expedited hearing.
Yes, fine.
The board.
But what's happened in relation to the storage and retention of fingerprints and the like?
We have a decision of the court which is contradictory, and whether the storage and retention on the microchip of the card is allowed or whether it is against the judgment, this is the issue for your lordships to decide. And we have learned that there has been destruction of the database following that judgment in 2015, 29th of May. But our instructions are that once something has been recorded electronically by way of information technology, it is impossible to completely delete the same.
It's a bit late.
Yes.
Tell me this, following the 2015 judgment, has the government issued new regulations relating to judicial review of the retention and preservation or destruction of data?
Yeah. The answer
They're waiting
is
this-
the negative, my lord, because the data protection is as it is. It provides no safeguard at all.
No, but they have said that they will do so. They've said they will comply, but they haven't yet complied with the judgment.
Yet complied, yes.
Do we have a clear note of what they've undertaken to do?
They are waiting, just like the population is waiting for the outcome of this matter, my lord.
No, there's a clear statement in the respondent's printed case as to what they accept and what their intention is.
So far, there has been nothing in the legislature
They may
and
not have
parliament.
done it, but they have said what their intention is in their printed case in this appeal.
I am not of much assistance on this issue, my lord.
Right.
Thank you, my lords.
Thank you very much indeed, Mr. Tiluk Harry. Mr. Muna Pillay, is there anything you wish to add? No. Thank you very much. Thank you. Well, the board will take a moment just to consider where it is. Mr. Guthrie, we want you to help us simply on one point, which really arises out of some of the things which Mr. Tilak Harry said at the very end. We'd just like to understand what the present position is relating to protections of the revised sort, which the court suggested. As we understand it, there was a reference to a database being destroyed after the judgment, but there's also been a reference to the scheme, at any rate, in relation to those who've signed up with the consent form operating. That seems to be probably most of the population, or a large chunk. Yeah. And then if it's operating, it's operating apparently without any protections. Is that right?
Well, I think I can help. I'm hoping so. And I should say I'm very grateful to Ms. Doma, who has been in contact with the authorities of Mauritius in the last 24 hours to make absolutely sure that what we're going to tell you is correct. Given when the Supreme Court delivered its judgment, plainly something had to be done to make sure that the government was not acting unlawfully. And given that the storage of the fingerprints on the MNIC database had been declared unconstitutional, it was realized that the then National Identity Card Particulars in Register Regulations 2013 would have to be repealed and replaced. That is one of the instruments in the clip which was handed up earlier. It was under the Particulars in Register Regulations 2013 that the fingerprints were stored on the MNIC database. The National Identity Card Civil Identity Register Regulations 2015 have replaced the previous position, and the copy is also included in the clip. Under the Civil Identity Register Regulations 2015, fingerprints have not been included among the material which is to be stored on the Civil Identity Register.
So 4, that's the Civil Identity Register Regulations 2015, do not include fingerprints.
Do not include fingerprints. To take care of, if you like, the situation until the government knew the opinion of the board, the National Identity Card Amendment Regulations 2015 have been made. You have a copy of that, and an applicant for a national identity card has now to make a declaration to the effect that he has no objection that his fingerprint minutiae be processed and recorded for the purposes of producing his identity card. I understand, this is how the declaration continues, this information will be erased permanently from the register once the identity card has been printed. So once the card has been produced and given to the person concerned,
with the fingerprints on it?
No, the fingerprints are not on it.
So what's the point of the fingerprints?
Well, because it means that you only issue the card to the right person.
But how do you know he's the right person?
Because you have his fingerprints at that stage, and he has agreed that you should have them at that stage. But
if you've only one set of fingerprints, how can you tell it's he?
Well, he gives his fingerprints. They are kept for the purposes of producing the card, which I understand takes about 14 days. The card is then given to him or her, and the fingerprints, once that has happened, the fingerprints have been destroyed. So all it does is make sure that the card is given to the right person.
But I thought the card had a chip in it.
Well, it has a chip in it, yes, but the chip...
Forgive me. I thought the card had a chip in it, and I thought the chip had what's called minutiae in it. And I thought the minutiae were a reduced version of the fingerprints, but possibly only 4 fingers rather than 10.
But they can't be retrieved from the card. From that point, the card is the only thing in existence. It has, I've got a Miss Doma's card here if anyone would like to see what it looks like. But the purpose of the fingerprint is simply to ensure that the card and the person are properly together.
Well, how do you use
the
fingerprint
visually on the card? Sorry?
Is the fingerprint...
No, it isn't. No, it isn't.
But how is the fingerprint used to check that you're giving the identity card back to the right person?
Well, because when he collects the card, he gives his fingerprints.
Again?
Right? Yes. So there's a card reader, so when he gets his card, he gives his fingerprints at that point.
And it's got to correspond to what is on the...
And he's got to correspond to the...
So it merely checks that at that point,
Yes.
the right person gets it, but there's no subsequent means.
There's no, the fingerprints are not kept after that point and won't be kept after
Either
that
on the
point.
central database
No.
or on the card.
No, exactly.
And what you would like...
Well, the minutiae are on the card, but they aren't retrievable from the card. Is that right?
On the card or in the
No,
chip?
in the chip in the
card?
card, in the chip of the card.
In the chip in
Yes.
the card?
Yeah.
Yes,
not
quite.
retrievable.
Sorry?
But they are not retrievable.
They're not retrievable.
Yes, our evidence is that it's not retrievable.
Yes. It's
So
not
is,
retrievable.
when you tell us about all this, not retrievable, is this just a holding position pending the overall resolution of this case and the overall legality or illegality of the Act?
Well, yes, certainly. Well, it has to be a holding position in the sense that the government will have to obviously take account of what your lordships say.
Well, suppose we simply dismiss the appeal.
Yeah.
What's going to happen then?
Well, as I understand it, the position will be as it is at present. In other words, the fingerprints will be destroyed once the cards are issued, so that the offensive part of the process, as the Supreme Court found, namely the storage of the data, will no longer exist.
So what will be retained indefinitely, if anything?
Nothing.
Everything that's civil identity.
Everything which is on the Civil Identity Register, which you find at Divider 5.
Divider 4, Clause 4, the list of...
4, I'm sorry, it's Divider 4.
Four doesn't include, as far as I can see, any fingerprints or fingerprint minutiae.
That's the point.
No, exactly.
So, well, I thought you were telling us a moment ago that the current cards did include fingerprint minutiae, but they...
No, the cards do, but the register doesn't.
Well, I see. Well,
That's right.
But why are you producing cards at all with irretrievable fingerprint minutiae on it?
Well, it's to make sure that the cards are attached to the person who they identify.
But if the material's not retrievable, how do you make sure
Because
how do you compare his fingerprint with...
He can't get the card otherwise.
Yes, but why is the fingerprint minutiae on the card at all?
Well, because there has to be a means of making sure that the card is delivered to the right person.
or
That can't be
subsequent.
right, surely. As I understood what you said a moment ago, it's the fingerprint record on the database, the temporary database, which ensures you're giving the card to the right person. He comes along, gives you his thumb, and it's got to match what's on the database.
Yes.
What you're being asked at the moment is, what's the point of having it, in addition, in irretrievable form on the card? Since if it's irretrievable, it would appear to serve no useful purpose at all.
Our instructions from the ministry at the time.
I just want to understand what he's doing. Given that we've chosen to ask him.
Well, I understand the ministry is...
Identified
Yeah.
for one-to-one identification. One-to-one identification.
Would you like to deal with it? Yeah. I thought I'd ask Miss Domo, because she has been most in...
What happens if you lose the card?
Pardon me?
I think you have to go through the process again.
You have to start all over again. If you lose the card,
Yes, you would have to start with the
You have to start
whole
all over
process
again.
again. You would have to start with the whole
And pay a
process
fee
again.
that time, which goes up if you lose it a second time.
I'm puzzled by this because I can understand that under the current provisions relating to the Civil Identity Register, there is no record there of fingerprints or fingerprint minutiae, but we do know, at least you've been telling us, that the card contains some fingerprint details, minutiae, and that seems to be consistent with Section 5.2 of the Act, which requires that. And none of these regulations has abolished or altered Section 5.2, has it? As far as I can see. So that presumably the cards do contain recoverable fingerprint minutiae at the moment. Is there anything which says they shouldn't do, or that Section 5.2 has been amended?
Section 5.2, my lords, has not been amended. In fact, the fingerprints, following the judgment of the Supreme Court, because the card was not declared, the taking of the card was not declared to be unconstitutional, the minutiae were retained on the chip of the national identity card. And
So they are recoverable, presumably, from the chip. Somebody
I
can
would
read
want
it.
to know what the board means by recovery.
Well, somebody
Can it be
could
read?
read it, and
One will only be able to read the encoded minutiae from the card
yes.
if there is a card reader. However, for the time being, government has not introduced any card readers at any police stations
I see.
to
But-
allow for one-to-one identification.
Yes, I see. So the purpose of having the fingerprints on the card would potentially be
To allow for
to
one
allow that, and you would then have someone who came in with a card, and in
Yes.
order to check he was the person who was entitled to it, you would use a card reader if you had one.
Indeed, my lord.
I see.
Indeed, my
And
lord.
in the future, going back to my point about what happens if we simply dismiss the appeal.
Yes.
In the future, what's going to happen then?
In the future, we would await for instructions from from the ministry on the possibility or likelihood even of having those card readers or not.
But you say, do you, on your side, that you have solved all the constitutional problems by eliminating any fingerprint material on the central register, and confining it in effect to the cards.
To the card, yes, this is
And
the
you
position.
say that you've done what the Supreme Court said should be done.
Yes,
So,
by
I mean, on your case, what is the what do? We simply leave the Supreme Court judgment to stand. It's a bit out of date now because matters have moved on, or you're not asking for any more, are you? You're just asking for the...
Speaking for myself, it appears to me that it would be very, very helpful to have what we've been described now written down on the two sides of a piece of A4, so there's no doubt precisely what the position is.
Yeah. Yeah.
Would that be a possible thing?
yes, yes.
I'll make sure that you have that very shortly.
Am I right? It is only irretrievable on the card because there is no card reader issued.
Yeah.
There
The
is no-
material is there to be read on
Yes.
the card if the requisite reader is issued.
Yes, if
Provided that the owner of the card delivers it up for that purpose.
Yes.
Yes,
Or walks within 10 centimetres of somebody who's got one of these machines.
yeah.
On your
and,
case.
I mean, in evidence before the Supreme Court, our witness stated that it would be quite impossible for anybody to have those card readers because they require security access modules and so on. It's all in the evidence of before the Supreme Court, my lords.
Yeah. My Lord, if I'd been invited to, I could have taken you to the evidence about the accessibility and the information on the card, which was dealt with in some detail before the Supreme Court.
Would that be included in the two sides of A4 that sets up?
Well, I could certainly give the page references. It's all in the evidence of.
Perhaps the page numbers can be
Yes.
put
Yes.
on the same piece of paper.
Are there many of them, and do you want us to just write them down now?
Well, if your lordships, I was going to take you.
Only to say that your opponent has a chance to
Yes.
know what...
Really, the passages begin at page 511. Of particular interest are 515 to 516, 551 to 557, 565 to 6, and 612 to 4. And the Supreme Court, of course, they found, and I think it's at the top of page 873, that they were satisfied that the arrangement...
And whose evidence is that?
The evidence of Mr. Rama and Mr. Pavadi.
Yes.
Right, so as regards what you're asking us or suggesting we do in relation to the Supreme Court, if we're with you otherwise, basically, you say you've complied with what the Supreme
Yes.
Court required, and we needn't say any more, or do we need
Yes,
to?
well, we would say
We just
that,
record
yes.
that, I
I
suppose.
mean, plainly one needs to keep one's... I mean, I noted what my Lord Sumption said about the statement in case. It's obviously subject to anything that your Lordship says in the judgment. But we consider, the government considers that the steps that it has taken have complied with the...
So your position is that you invite us to affirm the Court of Appeals, the Supreme Court's judgment in its entirety.
Yes, insofar as the judgment is in our favour, of course, we entirely support it, but we're perfectly content to live with the extent to which it was not in our favour.
You presumably accept that there's a disagree that there is a potential probably drafting inconsistency between the last two, in the sense that in one breath they seem to say, the Supreme Court, this scheme is authorised under Section 9(2) of the Constitution, and in the next breath they say it's invalid. What they meant, it seems to be, and I think Mr. Tilak-Harry accepts, that in principle such a scheme is valid, or can be valid, but this particular scheme didn't have sufficient protections.
And they identified what was wrong with it.
Right. So we could rephrase that on your case, but that would be a technical.
Yes, exactly.
Yeah.
Yes, exactly.
Yeah. Well, I think that's helpful.
Yeah.
Yes, thank you. Mr. Tilak-Harry,
there was only one other matter I was going to raise. I appreciate that I haven't been invited to do so, but it was simply this, that so there was some reference in the course of argument as to the significance of Section 3 read together with Section 9 of the Constitution. I was only going to tell your Lordships that that was fairly comprehensively dealt with by Lord Hoffman in the Matadine and Pointu case.
In the which one?
In the Matadine and Pointu case, which has been mentioned.
And I see, actually, I misread the Maycock case. So is it to the same effect as...
It effectively says that Section 3 is an operative section rather than just an introductory one. But it doesn't create rights in addition to those which it subsequently refers to, like save where that's necessary. So,
well, save where it's necessary is rather a big caveat.
Yes. Well,
in this particular instance...
Doesn't matter.
In this particular instance...
Section 9 is actually, in some ways...
Section 3, yes.
Yeah.
Yes.
Section 3 has a sort of defence section aspect to it, doesn't it? Balancing section 2.
But yes, it does. It has to be in the public interest. Yeah. So it's got a balancing exercise within Section 3. But I only just wanted to underline that it has been fairly recently considered by the board.
That's Matadine. Which tab was that?
I think it's 43.
Yeah, thank you. Right.
Yeah.
I think we've called on you, Ms. Demer, already, but thank you very much. Yes, Mr.
Reply very briefly, my lords. In reply, if I may, very briefly. The issue which your lordship raised about Section 5 of the NIC, 5(2), subsection 2, that is, no provision has been made about fingerprints and its minutiae to be contained on the card. This issue was raised during an application for injunction which was unsuccessful. Afterwards, regulations were made on October 3rd of October 2013. A copy is found in the booklet that has been put in by the respondents, tab 2.
They refer to fingerprints. Yes, I see.
Regulation retrospectively, so as to cater for the points of objection raised in that connection. And regarding the expert evidence, my lords, I would invite your lordships to consider the judgment at page 876, where...
But can we just pause a moment? You say, and I think you're correct, that there's no reference in Section 5, subsection 2 of the National Identity Card
to fingerprints.
To fingerprints.
Yes.
They're referred to in the 2013 regulations.
GN 237.
Yeah, which is tab 2 of the supplementary. But those regulations are abolished in their entirety, revoked in their entirety in 2015. And
Yes.
so, I mean, the question which arises, perhaps we ought to go back to Mr. Guthrie, but the question arises, what basis is there for identity cards which have any reference to any fingerprint material at the moment at all? Is that...
It's in regulation 8, which contains...
Your Lordship's observation, in fact, it would seem that there is no regulation.
Oh, perhaps it's the second...
Enable.
Is it the second set? Is it tab 5, the second set of...
Tab 4.
2004?
So it has been repealed by tab. Under your corrections, under the corrections of your Lordship's marks, I cannot see the provision for the card to contain minutiae of the fingerprints as per GN 177 of 2005. And reference of same is made in GN 178 of 2015. I'm sorry. That is a consent form. They are requiring citizens to sign a consent form that they consent to giving their fingerprints to obtain an ID card. This is to be found at tab 5.
Well, they're not requiring them to consent. If they want one of the cards, they've got to consent.
They want to obtain the card.
They don't have to get one of the cards yet.
Yes, so
Well, in a sense, they do require the consent because it is compulsory that you apply. It's compulsory that you apply for the card, and it's compulsory that you sign the consent form. So,
Well, except that it's not compulsory yet, as I understand it, to
Yeah.
January next year.
It's actually March next year, if one looks at it.
March, right.
my Lord, with
Well,
regard-
is the position then that the only basis for the fingerprint material in the cards is this notional consent pursuant to the application?
No, it's not, my lord, because it's the first of the documents in the clip. The identity card regulations refers to, at 8, every identity card issued shall, in addition to the information specified in section 5.2, contain barcode, card control number, and document security object. And then that
Takes you to...
it takes you back to the regulations, the definition section at 2. Document security action means the hash value of the data of an applicant for an identity card, which is electronically signed by the authority system. Hash value means the value computed from the data of an applicant for an identity card.
Oh, I see, that's the fingerprints, is it?
Yes.
Right, okay. Thank you.
it's not really
way of free.
particularly clear.
No.
This document
is
we're
the
getting will make it
justification for the
absolutely
fingerprint.
plain as a pikestaff.
Right. Sorry, Mr. Thiel-Harry, yes.
On the issue of the evidence of expert witnesses, on this issue, the Supreme Court of Mauritius was correct if we look at their observations at page 876 of the record, the last paragraph. And the Supreme Court, at page 876, the last paragraph, stated the following.
Yeah.
That's the source of the conclusion number 6 on page 880, is it?
The Supreme Court stated the following. We have examined with much attention the evidence of both witnesses, Rama and Pavadi. Although their testimonies might indicate that there is a legitimate aim for storing and collecting personal biometric data, we do not find that there have been sufficiently strong reasons advanced to establish that such storage and retention of data for an indefinite period is proportionate to the legitimate aim pursued.
Yeah.
On the other hand, witness Sukan has said enough to be impressed upon us the risk and damages which the storage and retention adopted by the defendants would entail.
Yes.
So it is my humble submission, my lords, the evidence of witness Sukan, which was considered unchallenged by the court during the proceedings.
Yeah.
Whatever he has said is relevant not only for the storage, be it on a database, it will be equally applicable for storage on the microchip of the contactless smart card. And also, there are no safeguards that are available to the citizen, be it legislation or be it physical safeguard against any abuse of his biometric data, be it on the card.
Well, we're not hearing a case about the new regulations.
Yes, ma'am.
We're simply trying to understand what the position is. If you say that the new regulations don't
Yes.
meet the constitutional requirement, that's a different case from the one which has been decided.
Yes.
So you may be right that Mr. Sukun's evidence has some bearing on it, but on the face of it, his evidence was addressing the old situation when there was material floating around the internet or the government IT systems and indeed outside Mauritius in some private company's hands.
Yes.
And all that's different once you confine the fingerprint material to the card.
So it's a whole system information technology.
Anyway, we've got the point, but I'm just pointing out that it doesn't quite arise automatically. You can't move the challenge to the new.
Well, I appreciate where, because of the way the course things have taken, I don't really have a right to reply, but that point about the safeguards in relation to the taking of fingerprints was found as a fact that the safeguards there were appropriate at the top of page 873. Where the Supreme Court says, taking into consideration the appropriate safeguards in the taking of fingerprints for their insertion in the cards and the relative limited degree of interference involved, we are led to conclude that such interference is proportionate to the legitimate aim pursued. So that the Supreme Court was clearly happy about everything up to it, and including the insertion into the card.
I see.
It was
Right.
it was the storage after that had taken place that they found was unsatisfactory.
Right. Well, now
It is my submissions, my lords, that the regulations that were made after the judgment do not address the issues in relation to safeguards that are lacking as per the expert witness Sukan for the appellant.
thank you.
Unless I can be of further assistance, my lords, I have done.
No, thank you very much indeed. The board is grateful to counsel and to those who prepared the papers, and will take time to consider its judgment, which will be delivered in the usual way.